Jeremy, I can't see you.
That's because I'm still in my Halloween costume.
What costume?
I'm dressed up as all the Amicus Briefs filed in support of the SEC. Welcome back to Legal Briefs, Amicus edition, and yes, Amicus because attorney John Deaton and 75,000 XRP holders filed their brief in opposition to the SEC, and it was fire. We'll get to that. But also a big surprise brief was filed, which we will also get to. The drinking game today is drink every time I say Amicus. Good luck with that. So, first, what are Amicus Briefs and why are they important? And why is it important that we now have 10 of these things filed in the Ripple versus SEC case, all against the SEC, I might add? Well, believe it or not, Amicus Briefs began all the way back in the days of the Roman Empire, where people not involved in the case, but who would be affected by the case, were sometimes asked by the court, invited to come in and talk with the judges and provide their insight to the courts. They became known as friends of the court, and that in Latin is amicus curiae. Here's an amicus who forgot to follow the font size rules from the court. It was very harsh back in the day. In U.S. courts, the rules for amicus are codified in Rule 29 of the Federal Rules of Civil Procedure, which basically lays out the specific rules for them, but in summary, they are generally allowed or not allowed at the discretion of the judge, with the only guidance being that amicus should bring to the table something new, something that the parties themselves haven't or can't raise. And in the Ripple versus SEC case, we now have about 8, 9, 10 amicus briefs filed. I lost count. They've all been coming in a flurry recently, all against the SEC at some level. The Chamber of Digital Commerce brief was fairly vanilla. The Blockchain Association, they did a good job of summarizing some of the key Ripple arguments. And late last night while I slept, the Crypto Council for Innovation, which I had never heard of before, filed a brief which was very interesting as well. So, interested blockchain organizations are really coming out in support of Ripple now, but it's really the company briefs that were most interesting to me because they brought out non-legal things that I think the judge should and would want to know. I'll look at the latest example from a company called SpendTheBits. Looking right at the first page, quote, SpendTheBits is a company based out of Alberta, Canada, founded by Jay Combo. SpendTheBits designed an application to transfer Bitcoin on the decentralized open source blockchain technology of the XRP ledger without Ripple's knowledge, consent, or assistance. And later in the same paragraph, quote, because XRP is the native token of the XRPL, SpendTheBits utilizes XRP in the operation of the application, close quote. So if I'm the judge and I kind of read the lawsuit, Ripple's reply, and I'm just trying to get my mind around what this case is about, this brief cues me in on a couple of things very clearly. First, anyone can use the XRP ledger, and XRP is kind of like having a key to use it. And further, Ripple can't even control who even uses the XRP ledger, and that makes it sound pretty decentralized, more similar to open source software. Maybe the judge has heard of like the Firefox browser from the 2000s, maybe she even used it back then. And she might not understand blockchain technology, but she knows that what this brief is describing definitely does not sound like something that is a security. And then you have an amicus brief coming at things from a completely different angle. Here's the brief from a company called iRemit, and let's take a quick look at page 1 of its brief. Quote, one of the chief mechanisms that iRemit employs to facilitate money transfers is the RippleNet software product. RippleNet, developed by defendant Ripple Labs Inc., allows customers to clear and settle cross-border financial transactions in a variety of ways. One of those ways is through software called On-Demand Liquidity, ODL, which uses a virtual cryptocurrency called XRP. XRP in turn runs on the XRP ledger, an open source technology not owned by Ripple, that can securely record international transactions almost instantaneously. So here the amicus is actually using XRP on Ripple software, so it's different than the SpendTheBits brief, but at the same time, look what the brief does to the SEC's contention that the principal reason anyone would buy XRP is to simply speculate on the price. Let's look at the bottom of page 2. Quote, iRemit and countless similar companies that use XRP for cross-border funds transfer on a daily basis are living proof. iRemit does not use XRP to speculate on it, nor does it consider XRP to be an investment whose inherent value is expected to increase over time, close quote. And there you have a real-life company talking about a real-life use for XRP. You know, not just a lawyer talking blah, 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 blah in a brief. Judges love this stuff. And just like that, one of the SEC's main arguments is sunk.
You say fight my battleship.
In fact, one of the things you see when you look at these amicus briefs is that some parts are filling in the holes for Ripple and some parts are making new holes in the SEC's argument. Kind of like a 10 against 1 fight. I mean, it's almost enough to make you feel bad for the SEC. Almost. But wait, there was one more surprise villager guy that wanted to jump in and beat up Mike a little bit more. And man, this one came out of the blue last night. Coinbase, the exchange. Yes, that Coinbase, which infamously delisted XRP shortly after the SEC filed the lawsuit against Ripple, Coinbase came out and jumped into the fray, filing a brief against the SEC as well. And what part of Michael did Coinbase attack? Now, it came out in support of Ripple's fair notice defense. And here it is in a scathing paragraph on page 18 of its brief. Quote, rather than initiate rulemaking, the SEC's current chair, Gary Gensler, has made a variety of assertions through speeches and testimony that have introduced fear and uncertainty in cryptocurrency markets. But the ongoing informal suggestions that certain digital assets may be securities under some as yet undisclosed standard, coupled with erratic shifts in the SEC's enforcement priorities, has now created untenable uncertainty for the US cryptocurrency industry and market participants. Close quote. Ouch. Brave words, Coinbase, brave words. Maybe back them up by relisting XRP. Just saying. I was curious though, reading the Coinbase brief, that there was no mention of their own internal analysis of XRP or their meeting with the SEC back in 2018, where the SEC didn't tell them that XRP was a security. But despite that, it was good to see Coinbase get involved, along with 6 companies and 3 organizations. And if that wasn't bad enough of a beating for the SEC, it all just got that much worse yesterday when attorney John Deaton and 75,000 XRP holders jumped into the fray. I had personally been waiting for this moment for some time, because it's one thing when companies are put out of business or damaged, but it's quite another when innocent retail purchasers are hurt. And this brief was a tour de force of the legal issues involved. But most importantly to me, it did 2 things in a way that no other brief has or could do. Now first, Deaton really destroys the SEC on the Howie from the efforts of others prong. In order for XRP to be a security, purchasers, me and you, had to have purchased XRP primarily looking to Ripple to increase the price. And in order to prove that, the SEC hired an expert to say that a reasonable purchaser of XRP, when he or she purchased XRP, was looking to Ripple to increase the price. And look at what Deaton does to that argument on page 16 of his brief. Quote, the SEC has offered no precedent supporting its representation theory. Because no precedent exists, the SEC's original intent was to rely on the rank speculation of an alleged expert, Expert 1, who failed to interview a single XRP holder before forming his opinions, close quote. And then later, quote, the SEC offers no evidence related to knowledge or conduct attributable to any amici or any XRP holders, close quote. And then Deaton finally highlights that when confronted with actual purchaser affidavits submitted into the record by actual XRP purchasers, and when confronted by those affidavits, the SEC expert actually backed off his opinion and admitted that he might have to come to a different conclusion and would need to do a lot more work and analysis in order to address the issue. So what you have there is an expert backtracking on a position, and that is very, very rare. I mean, the one reason you hire an expert is for him or her to form an opinion and stick with it. But apparently, to his credit, when the expert saw the affidavits submitted by Deaton, he felt the need to backtrack. Now, intellectually honest, yes, but it also leaves the SEC with possibly no evidence for one of the 4 prongs of the Howey test. It's like a black hole in the middle of the SEC's case. I said black hole, not toilet bowl. Oh well. And also on this topic, I have to point out some very inventive good lawyering, and it's on page 26 of the brief. In the SEC's motion, it made a big deal about how there were no use cases for XRP for the first 5 to 6 years of Ripple's existence, insinuating that people were therefore only buying it for speculative purposes. Now look how Deaton turns that on its head on page 26 of his brief. Quote, in sum, the SEC has failed to show that XRP purchasers relied on Ripple's efforts. If anything, the SEC's own argument proves the exact opposite to be true. According to the SEC, Ripple failed to find a, quote, use for XRP until the LDL product, which did not occur until 2018. Thus, it took Ripple over 6 years to find a use for XRP and 8 years to make its first sale of XRP for its purported purpose. No XRP holder could have a reasonable expectation of profits based on those efforts, close quote. You see what he did there? He did like a little legal aikido and turned the SEC's argument against it. Now, how can you be looking to Ripple to increase the value of XRP when they don't even have a use for it? That makes no sense. Also, Deaton's motion does another thing that is vital to the case, and I mentioned this last year. It humanizes the case. This is no longer just a regulatory agency attacking a company. Now there is an actual face to the harm that the lawsuit has caused. Look at page 19 of Deaton's brief. Quote, the SEC was well aware that the mere filing of this case would cause multi-billion losses to innocent third parties, he cited to Mr. Grunfest's letter. His warning was more than accurate because the damages were more than $15 billion, and the disruption of numerous innovative applications of XRP resulted. Buried underneath the $15 billion in losses are real people who have been severely harmed, not by market volatility, but because at best, the SEC fundamentally misunderstands the underlying technology, or at worst, has been deliberately misleading so as to arrogate for the SEC optionality as this litigation progressed, close quote. And that, I think, sums up what the judge needs to learn from this brief. Real people harmed by a government agency that is supposed to be protecting them, but apparently has bigger priorities other than protecting investors. I really enjoyed this brief. It was very well done. And now we have 10 amicus briefs, and they are all coming at the SEC from different angles. You might be thinking, wow, this is amazing. What's the downside, Jeremy? Well, there is one, and it's a time issue. As Attorney Filan said on Twitter this morning, folks, don't be surprised if tomorrow I'm posting a motion by the SEC asking for additional pages and additional time to respond to all these amicus briefs. It's coming, close quote. Ooh, sounds bad. But that being said, this amount of interest and support from the blockchain community is a good and beautiful thing, and I'm glad this case has become somewhat of a rallying cry and focal point against SEC tyranny. Thanks for watching.